Hello everyone. Today we are gonna study the second chapter of Business Law and Ethics, that is Indian Contract Act 1872. So in this video we are gonna discuss three subchapters, that is essential elements of a contract, offer and acceptance, void and voidable agreements, and the third chapter is consideration. So the first topic is contract. So contract is nothing but an agreement, and every contract is not an agreement, but every agreement is a contract. For an agreement to become a contract, it must be enforceable by law. So a contract must be legally binding agreement, should lays out rights and obligations. For example, if you're buying a bus ticket or getting a job, renting a house, all these are examples of contract. That means all these are enforceable by law. So, why do we need contracts? Clarity and trust. It avoids confusion and promotes good faith, minimizes risk, protects parties from potential losses or conflicts. Legal protection. It provides a basis for legal recourse if things go wrong. So the next topic is the Indian Contract Act 1872. This is the law that governs contracts in India, and it provides the rules for valid contracts and their enforcement. Next, see what are the essential elements of a valid contract. So there are three key elements. Let's dive into the three ingredients that make a valid contract. So think of it like a recipe. You need all three for it to work. So the first one, there has to be an offer. This is when one person proposes a deal. It has to be clear and specific. For example, I offer to sell you my car for 5 lakh rupees. It is a clear proposal or offer. Next, the other person has to accept that offer. They must agree to the exact terms without any changes. So they could say, I accept your offer to buy your car for 5 lakh rupees. If they said, I will give you 4 lakh rupees, that's not an acceptance, it's a new offer. And finally, there has to be consideration. This is the most important part. It's the something of value that is exchanged between the parties. This is for that of the agreement. In our car example, the consideration is the car itself and the 5 lakh rupees. If one person offers something and gets nothing in return, it is not legally binding contract. So, a contract is a promise for a promise, and to be legally enforceable, it needs offer, acceptance, and consideration. These are the three essential elements of a valid contract. The next topic is offer and acceptance, that is the building blocks of a contract. So let's see what is an offer. An offer is when a person shows their willingness to do or not to do something to get the other person to agree. The person making the offer is known as the offerer, and the person receiving it is the offeree. For example, A offers to sell his book to B for 100 rupees. So here A offers to sell his book to B for 100 rupees. A is the offerer and B is the offeree. The next topic is rules for a valid offer. First one, it must be clear and specific. Second one, must be communicated. That is, the offeree must know about the offer. You cannot accept an offer you doesn't know that exists. The third one, it can be written or oral. Offers can be made in any form. So let's say types of offers. There are two types of offers: specific offer and general offer. Specific offer are those made to a specific person or group. For example, I offer to sell my book to you is an example for specific offer. The second type is general offer. For example, it is made to the world at large. Anyone can accept it by fulfilling the conditions. Example, a reward for finding a lost dog is an example for general offer. The next topic is, when can an offer be revoked? So revoked means taken back. So an offer can be taken back at any time before it is accepted by the offeree. So we said, who is an offeree? One who is receiving the offer is the offeree. It's like sending a text message. You can delete the message on your end before the other person reads it. Once they read it, it's too late. So for an example, we can say, if A sends B a letter offering to sell his house, A can revoke the offer by sending another letter, but only if the second letter reaches B before B has mailed his acceptance. Okay, the next topic is acceptance. Acceptance is simply agreeing to the terms of an offer, but legally it's so much more. It's the final step that turns a mere offer into a binding legal contract. Think of it like flipping a switch. The offer is on, but it doesn't become a contract until you flip the acceptance switch. Now for the most important rule of all, your acceptance must be absolute and unqualified. What does that mean? It means you have to agree to all the terms exactly as they are without adding any conditions. So let's use a simple example. Imagine a girl named Tina offers to sell her toy car for 100 rupees. If you say, I will buy it for 100 rupees, if it also comes with the original box, that's not an acceptance. It's an counter offer. You have changed the terms, which means you have rejected the original offer. A true acceptance would be a simple and unconditional. I accept your offer to buy the toy car for 100 rupees. So the next topic is the golden rules of acceptance. So the first one is, it should be absolute and unqualified. That means acceptance must be unconditional. You must agree to all the terms exactly as they are. For example, Minna offers to sell her scooter for rupees 10,000 and Tina says she will buy it if she wins a war against Russia and lavender trees grow in Japan. The result is, this is not an acceptance. This is a counter offer. It kills the original offer. The second golden rule is that it should be communicated and timing must be communicated. You cannot accept an offer in your head. It must be communicated to the offerer. The person who made the offer should communicate it to the. The third rule is no silence. Silence does not mean acceptance. You must actively say yes. The fourth one is be timely. Acceptance must be given within the time limit started in the offer, or if no time is given, within a reasonable time. So the next topic is the race to revoke or revocation of acceptance. So you can revoke your acceptance at any time before it reaches the offerer. So for example, you sent a letter accepting a proposal. You then immediately send an email revoking it. If the email arrives before the letter, your acceptance is successfully revoked. The next topic is essentials of a valid contract. So the first one is offer and acceptance, as we mentioned earlier. There must be a clear proposal from one party, the offerer, and an unconditional agreement to it by the other party, the offeree. This creates a binding agreement. The second one is intention to create a legal relationship. The parties must have intended for their agreement to have legal consequences. Social or domestic agreements like a promise to meet for coffee don't typically have this intention. The third element is lawful consideration. The agreement must be supported by an exchange of something of value known as consideration. This is the something for something that both parties give up. And the fourth element is capacity of parties. The people entering the contract must be legally competent. This means they should be of legal age, of sound mind. and not disqualified from contracting by any law. The fifth element is free consent. The consent of the parties must be genuine and not influenced by coercion, undue influence, fraud, misrepresentation, or a mistake. The sixth element is lawful object and consideration. The purpose and subject matter of the contract must be legal and not opposed to public policy. An agreement to commit a crime, for example, is not a valid contract. Seventh element is certainty of terms. The terms of the agreement must be clear and precise. An agreement to sell a few tons of oil would be void for uncertainty. And the eighth element is possibility of performance. The agreement must be capable of being performed. A contract to perform an impossible act is enforceable. Okay, the next chapter is void and voidable agreements. So now we are gonna study about void agreements, deals that are unenforceable by law. They are not just problematic, they have no legal force from the very beginning. So there are many types of void agreements. First one is if considerations and objects are unlawful in part, and that comes under section 24. So those agreements where the consideration or object is illegal or against public policy, it is considered as void agreements. The second one is agreements without consideration. That comes under section 25, which we will discuss in our next slide. The next one is agreement in restraint of marriage. In simple terms, we can say getting married. That comes under section 26. And in section 27, agreement in restraint of trade. That is practicing a trade or profession. Agreement in restraint of legal proceedings, that means taking legal action, and that comes under section 28. And under 29, agreements void for uncertainties, that means the agreements with vague or unclear terms. And under section 30, agreements by way of wager. And wagering is a term which means agreements that are essentially bets on an uncertain event. So these are the types of void agreements. The next topic is no consideration, no contract. Section 25 states that an agreement made without consideration is void. A promise to give a gift is an agreement, but it's not a contract because nothing is exchanged. The law won't force the giver to follow through. And let's see exemption to the rule. First one is love and affection. A promise made out of natural love and affection between close relatives, and it must be in writing and registered. Past voluntary services. A promise to compensate someone for something they have already voluntarily done for the promiser. The third one is time barred debt. A promise made in writing to pay all or part of a debt barred by the law of limitation. Okay, so the next topic is voidable contract. An agreement that is enforceable by law at the option of one party but not the other. It is a valid agreement, but it contains a defect. That is, one party's consent was not free. The wronged party has the right to either cancel it or enforce it. It's like buying a product that can be returned. A void contract is like a product that was broken before you ever bought it. Now let's see each type of void agreements in detail. First one is restraint of marriage. Any agreement that restrains the marriage of a person is void. It is a fundamental right and a matter of public policy. Restraint of trade. Any agreement that restrains a person from exercising a lawful profession or business is void to that extent, to promote competition and protect a person's livelihood. The next one is restraint of legal proceedings. Any agreement that prevents a person from enforcing their rights in a court of law is void. This ensures everyone has a right to legal recourse. A contract states that a customer cannot sue the company for damages. This clause is void. Agreements void for uncertainty. An agreement whose name is not certain and cannot be made certain is void. The terms must be clear enough for a court to enforce them. Next one is agreement by way of wager. An agreement by way of wager, that means a bet, is void. The law will not help anyone recover money lost in a wager. Wagering agreements are against public policy. There is an exemption in this case, that is agreement related to horse racing where the prize money is at least rupees 500 are not considered as wagers. The next subchapter is consideration. The something for something of a contract is known as consideration. Something of value that is exchanged between the parties in an agreement. It is the price of the promise. It can be an act, an abstinence, that is refraining from doing something, or a promise to do or not to do something. Consideration is essential for every contract. Without it, the agreement is generally not enforceable. Now let's see the legal rules of consideration. It must be at the desire of the promiser. The act or promise must be done at the request of the person making the promise. It may move from the promisee or any other person. This is a unique aspect of the Indian law. The consideration doesn't have to come directly from the person to whom the promise is made. Then consideration must be something of value. It doesn't need to be adequate, but it must be real. The court may look at inadequacy to see if consent was free. And it can be past, present or future. Past means something already done before the promise is made. Present or executed, that means something done at the same time as the promise. Future or executory, that is a promise to be performed in the future. Now let's see key rules regarding consideration. It must be at the desire of the promiser. It may move from the promisee or any other person. And consideration must be something of value. However, the law does not require the consideration to be adequate, that is of equal value. Must not be illusory or opposed to public. Can be an act or abstinence, past, present or future. An agreement without consideration is void by law. However, there are exceptions where an agreement without consideration is valid, such as a written promise made on account of natural love and affection between close relatives, a promise to compensate for voluntary services which is already done, and promise made in writing to pay a time bad debt. That's all with today's class. Thank you.